side. Let me know if you want rebuttal time when you approach, and we'll reserve up to 5 minutes rebuttal time for you. First case is Gitland versus Citizens Property. Operator, you ready to proceed?
Yes, Your Honor. May it please the court, Jeffrey Marks on behalf of the appellant Mark Gitland. I'd like to reserve 5 minutes for rebuttal. And let me say at the outset, it's a pleasure to be presenting the oral argument in person. This is an appeal from an order denying attorney's fees, essentially a summary judgment order, following a Hurricane Irma claim. The insured's home was damaged during Hurricane Irma. The insured presented his claim to Citizens. Citizens responded by stating that we don't believe the damages exceed your deductible. We estimate your damages at $3,252. The insured retained counsel. The insured then presented to Citizens a detailed estimate showing that damages were in excess of $43,000, and said to the insurance company in November 6th, 2018, please respond if you want to resolve this. You have 14 days to do so. And in essence,
and before the November letter,
yes,
was there a denial on the benefits?
was there a denial?
Denial.
I can't say that there was a complete denial.
Was there, and if so, if there was an incomplete denial, point me to where it was.
Well, what it was, Your Honor, was a statement that we don't believe your damages exceed your deductible. So I would argue that that's a de facto denial of coverage because the insured.
Well, but they said there was coverage. Okay, it just the deductible.
I'm not quarreling, and I don't think we've never taken the position that the insurance company said, as it has in cases in which fees are warranted, professional judgment doctrine, which insurance company said there's no coverage for this claim. Didn't take that position, no, we're not taking that position here. What we're saying is that the evaluation of the claim compared to the ultimate appraisal award is the functional equivalent of a denial of coverage. And when you evaluate the claim at $3,000 and you get an appraisal award of more than 10 times that amount, that is in essence a denial of coverage. But I can't.
It doesn't, the case will say that there has to be an incorrect denial of benefits.
And that's what we're saying, Your Honor, is that by evaluating the claim at the value that the insurance company did and the resulting award being so far in excess of what that valuation was, that amounts to a denial, an incorrect denial of coverage. But it's also, there's more in the case law in terms of when the court should impose attorney's fees under 627.2A professional judgment.
And here you're saying simply because of the fact that the payment came post-suit. And I think that's really getting to the crux of the issue here, is that the payment came after suit was filed.
That's part of it. The other part of it is that there was no, and it's a critical fact, is that when the insured sent in his evaluation and said that my claim is worth $43,000 or so, said, please respond 14 days. There were crickets, no response for 6 weeks.
That's kind of what I think the trial court was looking at when it granted the Citizens motion for summary judgment, because you look at the case, the claim came in a year before the response, correct?
Correct.
Okay. And so it took the insured a year to file their claim with the money damages, what they had lost. But then they sent a letter to the insurer saying, here, we want to discuss this. I think is what it says. I think something to that effect. It wasn't like threatening litigation, right?
I don't believe the letter
Okay.
we read that.
But then it gave the insurer only 14 days to respond. And the insurer responded within 30 days.
No, 6 weeks, Your Honor. It was 6 weeks when the insurance company finally said we demand appraisal.
Oh, I'm sorry, 6 weeks.
Right.
Not a year.
Well,
But before they were served with the lawsuit. I think that, right?
no, I beg to differ on the service of the lawsuit. Its service is perfected by serving the chief financial officer of the state of Florida by statute. Citizens was served with the lawsuit, but it did not receive the lawsuit notice in terms of an actual copy of the lawsuit until a couple of days later.
So wait, is what you're saying that Citizens had been served, before it invoked appraisal?
Yes, Your Honor. The 627,
Okay, tell me where that is in the record.
sure, Your Honor. Two things. One, if you'll look at record 26, which is the notice of service and process by the state of Florida, the chief financial officer, and you look at 624.423, 624.423 says that when you're serving an insurance company, you serve.
Oh, I'm aware of that.
Right, yeah, but service is protected on serving the chief financial officer.
Yes.
So
What's
technically,
the date though?
the date of service was December 26th, was the date that service was received by the chief financial officer. Now, I'm not.
The appraisal was demanded on December 23rd.
Right,
Correct, right, and I'm not,
but I'm confused on what you just said. You said service was
Well,
perfected.
yeah,
before
service-
the demand.
service is perfected upon receipt on service of the chief financial
You told me
officer.
that it was the 26th of
And-
December?
And it was received in our office by December 20, service was received in my office by December 26th. So the insurance company was served, the chief financial officer received the service on the 26th. Citizens finally responded to the letter on December 23rd. I'm not arguing that that's the
Citizens
correction.
is saying they weren't
Facts.
served until January the 2nd.
And that's not an accurate statement of law.
Where did they get that? Why is that not?
Because that's when they received, the January 17th date, I believe, is when they answered the complaint. Citizens gets a copy under the service law statute, under 624, when the
But if
department
Okay,
insurance is.
I just gotta answer my question like this. The letter for the demand for the appraisal was the 23rd of December.
From the insurance company to the insured, yes,
Yeah, so that was the only demand. for
Correct.
appraisal.
correct,
But you're saying service was the 26th.
correct.
Okay, so I guess that was back to my question, the demand preceded service.
And that, I can't, I'm not.
Okay, that's not what I heard you say, maybe I misunderstood what you said.
No, the intimation, and let me correct it, because I
Okay.
think there was a sort of, I wasn't as clear as I wanted to be. It was intimation that the insurance company was served in January in the lower court. There was intimation that the insurance company, because it didn't have notice of this lawsuit, all right, that somehow they should get out from under the obligations of 627.428. That's not an accurate, correct statement. Our position is that because the insurance company did nothing in response to the plaintiff's presentation of damages that is more than tenfold what they estimated, each 2 weeks, please respond. 3 weeks go by, 4 weeks go by, 5 weeks, 6 weeks. Insured is left with no
What
position.
obligation does the insurance company have to respond to a 14-day demand? from the
There is no statutory
That's
obligation.
meaningless.
It's, I don't want to call it arbitrary, but I could, if you told me that, that it's not a legal requirement. But the problem,
Would you agree that the company didn't have notice of the lawsuit or service until after the appraisal was demanded? Can you agree to that?
I would agree that they didn't have notice of the lawsuit, and I would agree that they didn't have service of the lawsuit. But our point is that, I agree, Rob. Okay?
I mean, we can argue about the significance of that, but let's just make sure we're on the same page. 'Cause I thought I heard, as Judge Smith said earlier, I thought I heard you say that they had notice and or service prior to demanding appraisal, and my reading of the record is they definitely did not.
If that's what I'm mistaken, that's what I said. It was not an accurate statement. What I want to be clear about is that our point, the point that I think got lost in the trial court, was that the insured got nothing in response from the insurance company.
Well, wait, isn't your point that you're entitled to fees under a confession of judgment theory?
627.428 and under the analysis.
Under a confession of judgment.
Correct.
theory.
Correct.
And isn't the general law on confession that the triggering event for the liability of the defendant is that they have notice of the lawsuit?
It's one of the triggering events. It must be an incorrect denial of benefits. Our position is not solely tethered to the confession of judgment doctrine. It's also that we think we're entitled to fees under 627.428 in the case law, in which the courts have analyzed why one has to file suit and why that triggers entitlement to fees under the statute. So it's both. The confession of judgment doctrine, I think, is a little more narrow in terms of its analysis because it requires an incorrect denial of benefits. And our position is that the interpretation of incorrect denial of benefits in this case is a gross undervaluation of the claim and a statement that was ultimately proved correct by arbitration. And the second part is that the insured, it forces the insured to resort to litigation to recover. We think we've met that problem because the insurance company had never had any intention of paying the claim because they evaluated early on this claim $3,500 below the deductible.
That's really not apparent from the record. I mean, that's kind of speculation on your part.
Well, the denial, the original denial letter said we looked at your claim and we don't think you meet the deductible and we think the evaluation is $3,000. And then in response to a presentation of a report that showed $45,000 or so, and they said we just think by
demanded appraisal. And the plaintiffs voluntarily went and through appraisal and agreed to the state
Correct.
order.
correct.
And did what the policy said. I guess I'm having a hard time finding where the insurer gave the insurer on this record, okay? Because this record is really a discrete set of facts here, right?
Agreed.
Okay,
Yeah, it's very narrow.
so this is all we have to look at. And on these facts, help me find out where the insurer gave citizens the opportunity to look at the valuation here before the insured went off and filed suit.
By the presentation of the demand letter saying, here's our
The
evidence.
14-day demand letter that
Correct.
came a year after the coverage.
Correct. And there's no
And
evidence
that
in the
demand
record.
letter was submitted on November the 6th of 2018, and within 6 weeks, the appraisal had been requested.
That's correct. And so but our position is that the reason why that request for appraisal does not get the insurance company out of entitlement to attorney's fees is looking at the case law, which says that the insured had to resort to litigation. Our position is that by grossly undervaluing the damages in this case,
If
the
they didn't
record
have
is,
notice or service, how does this lawsuit even enter into the decision to request appraisal?
well, it was reasonably necessary for the insured to file suit to get the insurance company to then proceed to the issue of appraisal. And
It sounds like you're trying to make what amounts to a procedural bad faith claim based on the time that the insurer took to pay the claim, but your fee claim really does hinge on when the insurer had notice of the suit, even accepting the fact that in a vacuum, your client filed suit, which eventually led to payment of benefits greater than what had been offered, but that was as a result of the appraisal that the insurer requested before it knew it was sued.
And my answer to that is, I guess you could call it bad faith, although the case law says that the Supreme Court took out the bad faith requirement of determining whether or not.
Well, and this isn't really a bad faith
But-
case.
No, and the reason why I think that we get there, our argument is predicated on the fact that when the presentation was made to the insurance company, you grossly undervalued this claim, and insured gets nothing in response. Okay, it has no response for 6 weeks. The suit was filed after the 2-week period. And we think that that is a reasonable amount of time, a reasonable notice to the insurance company that they have undervalued.
On what day was the suit filed?
The suit was filed on
December 3rd.
December 3rd, right? And so.
And it took until the 23rd to get it served?
There's the process goes to the Department of
I'm
Insurance.
sorry, the 26th.
And that's what the notice says, is that when the State Department of Insurance says, or the Chief Financial Officer said that he received the case. The working in the sphere of insurance company law, it's necessary sometimes to file suit because that then triggers the responsibilities and obligations and rights of the parties. In this situation, the insured said, here's my appraisal, here's my estimate. how can you be so far off? And I was expanding the scope of that language, but that's the essence of the letter. You said $3,000 and we say $43,000. Get back to us, please, in 2 weeks and let us know, what you want to do. And 2 weeks comes and goes and nothing happens. And 3 weeks comes and goes and 6 weeks comes and goes.
But this response, I mean, I know you keep talking about the response and the insurance company took such a delay, but this response came a year later.
And there's nothing in the records to explain why
No,
there
it was
was.
not, and that's what we're left with.
But I don't think that's relevant, that the time in which the claim was presented.
Isn't it a little bit disingenuous to sit on the claim for a year and then send a letter saying, by the way, you got 14 days to do something about this?
I think that describing it as disingenuous is a little harsh. I think that I could think of a half a dozen factors as to why it would take that long. Post-hurricane, we all know how difficult it is to get things done, from contractors to insurance companies to dealing with.
Wouldn't your case be, you would agree that your case would be a lot different if the appraisal demand had come after Citizens was served?
I can't disagree with that. I mean, I know if I could, rework the timing, obviously, I think we would fit much more strongly into the, necessity of filing suit, producing a result. But I want to be clear about what my argument is predicated on. There's no way that the insurance company was paying this claim because they grossly undervalued it.
But we can't know that because they invoked appraisal before they knew about the
You're
lawsuit,
at
which
5 minutes. If you care to keep going, that's up to you. I just want to let you know.
I just want to answer that question, and I appreciate that. I appreciate that another time. I think you do know that because when the tease out is when you have an insurance company evaluating a claim at $3,500 or so, and you have an appraisal award that's more than 10 times that, the only inference that can be drawn is that it was necessary for the insurer to take the action that it did because the gross undervaluation of the claim is the functional equivalent of a denial of coverage. And that's why we think we're entitled to attorney's fees, and that's why we fit under 627-428, and that's why we are asking the court reverses. Thank you.
Very good. You have 4 minutes when you're back up.
Good morning, Your Honors. May it please the court, Catherine Under of Lewis Bisboy on behalf of Citizens Property Insurance Corporation. We're requesting that this court affirm the final summary judgment in Citizens' favor on all grounds. As this court seems to be aware, there are no issues of fact here. In fact, at the record on page 354, it's transcript page 7, line 2 through 23. The insured's trial counsel specifically agreed on the record that there were no issues of fact. So the record that we have is the body of evidence that we have. And if we look at that, this was not a denial of insurance coverage. The claim was presented to Citizens in September of 2017, approximately 9 days after the hurricane damage occurred. Citizens immediately acknowledged the claim, and insurance was extended on October 14 of 2017. It fell within the hurricane deductible, which was about $4,400, so no payment was actually made. That was the last Citizens heard about anything from this claim until over a year later on November 16, when plaintiff's counsel submitted a letter to Citizens. And Your Honors, that plaintiff's counsel actually acknowledged in this letter, and this is record page 339 that I'm reading from, they acknowledged receipt of the payment of undisputed proceeds to amount, which was unilaterally determined and paid by Citizens pursuant to its obligations to the terms of the policy. So Your Honor, they agreed that there was coverage extended under the policy, notwithstanding the fact that it fell within the hurricane deductible.
What do we make of the fact that the offer from Citizens initially was in the $3,000 range and ultimately the award was 10 times that amount?
For the purposes of this
Is that
litigation,
sort of a functional denial, looking at the amount of the offer? I mean, was this ever going to end any other way than with a lawsuit?
no, Your Honor, that's incorrect under the facts in this case, because as the courts acknowledged, this appraisal was demanded prior to Citizens' notice of the litigation or service with the lawsuit. There's no question
So
on
when
that.
Citizens makes a $3,000 offer, they probably have a pretty good idea that a lawsuit's going to come their way, right?
I don't believe that to be the case, Your Honor. In this case specifically, Citizens extended coverage and never heard back from the plaintiffs indicating I mean, we can speculate as to what that indicated, but for over a year, nothing was done on the claim. There was never any back and forth discussion. There was never any proof of loss submitted. There was no other communications up until this November 16th of 2018 communication that was received that included an estimate that was for $43,000. And at that point, Your Honors, that's when Citizens said, okay, under the terms of the policy, we're demanding appraisal because there's obviously a dispute over the scope of coverage in this case. And immediately upon the appraisal occurring in May of 2019, that's when Citizens paid the appraisal award. There was never any question. The appraisal was demanded pursuant to the policy. The litigation in this case was never a necessary catalyst to anything. The insured gained nothing by filing the litigation. Citizens was always going to demand appraisal. There was never any notice on the part of Citizens.
What litigation activity is there on this record besides the filing of the complaint, the staying of the action, and the end game?
Very, very little, Your Honor. The record supports that defendant filed an answering affirmative defenses, seeking appraisal and demanding appraisal, saying that there was no breach of any policy.
And they had already demanded the appraisal.
And they had already demanded appraisal, citing the appraisal provision. There was a motion to strike our affirmative defenses, saying they were insufficient. Citizens immediately moved to compel the appraisal, and an agreed order was entered allowing the appraisal to move forward and stay in the litigation. So that was the only litigation that ever occurred, was on the appraisal.
So Citizens had to move to compel appraisal after invoking appraisal in the first instance?
I'm sorry.
You said that Citizens had to file a motion to compel appraisal.
We did. Citizens did file a motion to compel appraisal because it was after we were served with the litigation. So now we were in litigation and we were still demanding appraisal, but that was the basis, was the pre-suit demand for appraisal was the basis for the motion to compel appraisal in the litigation.
And the plaintiff ultimately did not oppose, they agreed to an order.
That's correct, Judge. That's absolutely correct. There was never any opposition to appraisal. So the entirety of this time, appraisal was always going to occur whether there was litigation or not. And the body of case law that we have is specifically goes against the plaintiff's position in this case, and the appellant's position in this case, including this court's Hill case. It's Hill versus State Farm, cited in the briefs. It's 35 Southern 3rd 956. And what the court says there is, it's apparent that some lawyers have read more into Goff, which is one of the decisions that appellant's counsel is relying on, than this court intended. Adjusting and settling property claims under insurance policies is never an easy process. It requires a level of good faith and cooperation from all parties. The law does not provide any general mechanism to impose attorney's fees against one party or the other, merely because the negotiation process is difficult. It is only when the claims adjusting process breaks down and the parties are no longer working to resolve the claim within the contract, but are taking steps to breach the contract, that the insured may be entitled to award fees under 627-428. This is also followed by the 4th DCA in the Esposito case that we cited. TriStar admonishes against this type of litigation tactic. Your Honor, all of the case law supports Citizens in this case, where they were doing what they were supposed to do under the insurance policy by demanding appraisal and complying with the terms of the policy. And notwithstanding that, the insured took it upon themselves to file litigation. It was never necessary. Citizens wasn't on notice when the appraisal came in, and it wasn't a necessary catalyst to anything to enforce the policy in this case. So if Your Honors have no further questions, we would request that you affirm on all grounds.
I think I have 2 points to make, and I'll try to actually be 2 points. So sometimes people say that. The point that we're trying to make here, and counsel correctly referred to the case law, which says that the claims process has broken down. Claims process here was broken at the initial evaluation of $3,500, and then nothing further from the insurance company. There's nothing in the record to show that the insurance company made a demand for pre-suit obligations. There's no suggestion in there that they asked for proofs of loss or anything like that. It was simply an evaluation of a claim that was grossly, as facts proved out, undervalued. And so when the insured then comes back and says, my damages are $45,000, here's an estimate, and gets no response, the insured is only left with one recourse, which is the right to bring suit. So there's no suggestion that bringing the suit was nefarious or inappropriate or improper. So from the insurance perspective, the claim process did break down, because when you get a evaluation of a claim of $3,500 and you get an arbitration award 10 times that amount, and you get nothing from the insurance company saying, you know, they could have asked for appraisal in the evaluation, initial evaluation of $3,500 would have been something. The insured went out, got its documentation, and didn't hear anything from the insurance company. When you don't hear anything from the insurance company, you know, how long is an insured supposed to sit around when the clock is ticking? And the insured did what anybody did, which is they filed suit. And I don't think it matters as to when the insurance company got notice of the suit. The suit was filed, the claims process had, because it was broken down and resulting in an appraisal that was 10 times in excess. And so that's why I keep on harping on that point, that a claim, the result, an award that results in 10 times in excess of what the initial evaluation is a functional equivalent of the claim process breaking down, and forced the insured to file suit, and the insured got a result of the recovery that it was entitled to. And so for those reasons, we think that entitlement to attorney's fees under 627.428 is appropriate in this case, and we ask that you reverse.
Thank you, sir. Next case on the docket is Huntsville County Aviation Authority versus Todd Enriquez Property Appraisal.